Nnamdi Kanu has gone on appeal against the judgment of the Federal High Court that convicted him last year. Remember that Honorable Justice James Omotosho, in the judgment of the Federal High Court, made pronouncements against Nnamdi Kanu and sentenced him to terms of imprisonment. A few days ago, Mazi Nnamdi Kanu, has filed a notice of appeal against that judgment. Remember, in law, Nnamdi had 90 days to file an appeal against the judgment. Some people thought that he was going to file the appeal almost immediately after the pronouncement was made against him. But I think he took his time and then decided to just make sure that he files it within the 90 days. So he's still within the 90 days at the time of the filing of this notice of appeal. So in this video, we look at the grounds of appeal in summary. There are quite many, but we look at them in summary. We look at the position of the law, and we then look at what to expect. Nnamdi Kanu is the person that has filed the appeal by himself. And that is why you say, take notice that Nnamdi Kanu, lawyers will see that this is not the regular language of the notice of appeal, okay? But he's saying, Nnamdi Kanu, so it's allowed. He is a person that has filed the notice of appeal against the judgments that was delivered against him. And he was sentenced. He said that he was sentenced for 7 numbers of offenses. I hereby appeal as follows. Ground number 1, he's saying that the judge was wrong in law for failing to resolve what Nnamdi calls procedural and competence consequences of the foundational disruption of the original trial processes in September 2017. You remember that Operation Python dance that something happened in his father's compound in Afaruku, in Abia State. And that led to Nnamdi running for his life. So Nnamdi is saying that when he came back for trial, the judge ought to have first of all resolved that very issue before proceeding. That's ground number 1. Ground number 2, he's saying that the judge was in error by failing or refusing or neglecting to hear and determine his pending preliminary objection challenging the competence of the proceedings. Remember that Nnamdi had filed an objection challenging the competence of the proceedings at the Federal High Court. So he's saying that the judge was wrong in failing to have determined that. Ground number 3, he is saying that the judge was in error by proceeding to judgment and convicting him while his application for bail was yet to be determined. That's what Nnamdi is saying. That's ground number 3. That the judge should have determined his bail application before proceeding to hear and determine the entire matter. Well, lawyers in the Ministry of Justice will have a response to that. They may likely say that bail is at the discretion of the judge and so on, but it's left for them, right? Number 4, he's saying that the judge misdirected himself when he treated his absence from 2017 to 2021 as a basis for adverse inference without proper consideration of evidence that compelled his absence. Still remember that invasion of his father's house in Afaruku. Ground number 5, Nnamdi is saying that the judge was in error in trying and convicting him upon proceedings previously declared nullity ab initio by the Court of Appeal. Remember that the Court of Appeal had said that the trial of Nnamdi Kanu was a nullity. The Court of Appeal had said that. But I see the Ministry of Justice also replying that the matter had gone up to the Supreme Court, and the Supreme Court did not say it's exactly the same thing. Supreme Court ordered for a trial. But that's one of the grounds that Nnamdi has raised. Ground number 6, Nnamdi is saying that the judge was in error by treating an interim stay of execution order as capable of lawfully suspending the operative effect of the Court of Appeal's final criminal judgment. So you remember that the Court of Appeal had said release him. Federal government said they filed notice of appeal they filed stay of execution. And Nnamdi is saying that the judge was wrong to have given recognition to that stay of execution instead of discharging him. 7, that the judge was in error in subjecting him to renewed jeopardy in respect of substantially overlapping facts. So he's saying that the judge was in error to have tried him after he had already been tried in the same matter, the same facts, and so on, and the Court of Appeal had even made a pronouncement in his favor. Ground number 8, he's saying that the trial judge was in error and that he misapplied the judgment of the Supreme Court, which talked about taking the matter back to the trial court. Ground number 8, Nnamdi is saying that the trial judge was in error of law by convicting and sentencing him under the Terrorism Prevention Amendment Act 2013, which Nnamdi says was repealed in 2022. Okay? Ground number 10, Nnamdi is saying that the judge was wrong in law in assuming jurisdiction over extraterritorial allegations. Remember that most of the allegations was that he made a broadcast from the United Kingdom, which was heard in Nigeria. Nnamdi is saying that the judge was wrong to have assumed jurisdiction over something that did not happen in Nigeria. Number 11, Nnamdi is saying that the judge was wrong in law to have denied him fair hearing by proceeding to judgment without permitting him to file and present a final written address. Remember that that's one of the complaints that Nnamdi raised at the trial court. He said he has not been given an opportunity to file a final written address. That's one of the grounds now that he has taken to the Court of Appeal. Number 12, he said that the judge was wrong in law by convicting him on count 1 without proof beyond reasonable doubt of any preparatory act constituting the actus reus, that's the act itself of the offense. Ground number 13, Nnamdi is saying that the trial judge was in error in convicting him on count 2 based on alleged broadcast without proper authentication, proof of transmission of the broadcast, authorship of the broadcast by him, intimidating effect on the populace. That's one of the grounds, okay? Ground number 14, Nnamdi is saying that the judge was wrong in law to have convicted him of ground number 3 without cogent admissible evidence of membership or leadership of IPOB. Nnamdi is saying there was no evidence that he's a member of IPOB or that he's the leader of IPOB. There was no cogent and verifiable evidence before the court, and the court went ahead to convict him. Okay? Number 15, Nnamdi is saying that the judge was in error of law by convicting him on counts 4 and 5 without proof of communication of the alleged incitements. Remember that one of the allegations was that Nnamdi, through his radio broadcast, has been inciting people to take up arms in the East against the government of Nigeria, against policemen and so on. Nnamdi is saying that there was no evidence of communication of that. There was no proof of communication of that against him. Ground number 16, Nnamdi is saying that the learned trial judge was wrong in convicting him of count 6 without proof that any bomb or explosive device was manufactured or that any person acted on the alleged direction by him. 17, he is saying that the judge was wrong by convicting him on count 7 without proper proof of possession or importation, okay, of transmitters. 18, he is saying that the judge was wrong to have overruled his no-case submission. Remember that the judge had overruled Nnamdi's no-case submission and asked him to enter his defense. Nnamdi is saying that the judge was wrong to have overruled that no-case submission, that there was every reason for the judge to have let him go. Number 19, he is saying that the trial court was in error of law by convicting him without proof by admissible evidence that the alleged crimes occurred or of the essential prohibited consequences required by the count failure of corpus delicti. Okay? 20, he's saying that the decision of the learned trial judge is unreasonable, unwarranted, and cannot be supported by law having regard to the weight of admissible evidence. 21, he's saying that the judge failed to apply the African Charter on Human and People's Rights, which is a binding legislation to afford him fair trial and liberty. And 22, Nnamdi says that the judge was wrong in law in imposing sentence without taking his allocutus. You know that allocutus that is usually given to an accused person who has been convicted. Before sentencing, the accused person is usually given an opportunity to say something, possibly plead for leniency. Nnamdi is saying that he was not in the courtroom. He was not allowed to stay in the courtroom and make his allocutus. And that by not allowing him to be in the courtroom and make allocutus before sentencing, that the judge was wrong in law. Okay? So those are the grounds of appeal that Nnamdi has raised. Nnamdi has raised a total of 21 grounds, 22 grounds of appeal. It's actually a long notice of appeal. The particulars are there and so on, but because of time, we cannot bring in the particulars one after the other. Now, what are the reliefs that Nnamdi is seeking? Because in law, when you file a notice of appeal, you raise the grounds of appeal. The next thing you do is to tell the court of appeal what you want the court of appeal to do for you. That is called in law reliefs. So what are the reliefs sought? 1, an order of the court of appeal allowing the appeal. That is, agree with this appeal and set aside the judgment of the trial court. 2, an order of the court of appeal quashing the conviction. Remove all that conviction that was made against me. Okay? 3, an order of the court of appeal quashing, reversing, and setting aside the sentences and punishment imposed on Nnamdi Kanu. Okay? Number 4, an order of the Court of Appeal discharging and acquitting Nnamdi Kanu in respect of all the counts of the charge that was presented against him at the Federal High Court. Number 5, Nnamdi says, for such further orders as this Honorable Court may deem fit to make in my favor in the circumstances of this appeal. Now, let's look at the position of the law on this. Number 1, the notice of appeal is signed personally by Nnamdi Kanu. I said that from the beginning. By law, a person who has been convicted and sentenced to terms of imprisonment, he has the right to file his notice of appeal by himself or by a legal practitioner of his choice. In this case, Nnamdi has chosen to file the notice of appeal by himself. That is within the confines of the law, permitted. Number 2, having filed the notice of appeal, Nnamdi has to go to the registry or to the registrar of the Federal High Court and pay the prescribed fees to the registrar. His appeal can be, to be paid to the registrar may be, because of the volume, can be up to 5 million, it can be up to 3 million, it can be up to 2 million, depending on the volume. And the registrar will be expected to transmit that in not less than 12 volumes or sometimes 15 volumes from the Federal High Court Abuja, where he was tried, to the Court of Appeal Abuja, where the matter has been appealed to. Okay? Transmission to the Court of Appeal. Number 3, next will be for Nnamdi to sit back and prepare his brief of arguments into sufficient copies. It will be sometimes as big as this. He will prepare his brief of argument, stating the facts, stating the law in support of his notice of appeal, and then telling the Court of Appeal to discharge him because of this law, because of this fact, and so on. The brief of argument will now have to be served on the Attorney General of the Federation, who will respond or assign it to a private legal practitioner and give him the fiat to prosecute for the federal government. Remember that at the trial court, it was done by a Womolo, Senior Advocate of Nigeria, through the fiat of the Federal Attorney General, and then the Attorney General can decide to do the same thing in the appeal, and then the appeal will be heard. Now, Attorney General's reply will be served on Nnamdi Kanu, and when that is done, Nnamdi has the right to file what is called reply brief. When Nnamdi files reply brief, that means all the 3 briefs have entered, and the appeal is ripe for the Court of Appeal to fix a date and then hear the parties, get it adopted, and then give judgment. When all the briefs are filed in, the Court of Appeal will hear the parties who will be expected to adopt their briefs of argument. The court will then adjourn to deliver its judgment on the appeal within 90 days. Once the appeal is adopted, judgment must, as a requirement of law, be decided within 90 days. Judges will tell you that they do not want to miss the 90 days mark because it's a constitutional requirement. If you miss it, NJC queries you. So that is why within 90 days of the adoption, judgment is going to be delivered, and Nnamdi will know, his fate in the matter. Nnamdi can represent himself at the Court of Appeal. He can go to the Court of Appeal and argue his appeal. It's allowed. If he feels he can do that, if he knows that he has what it takes to do it, the law allows him to do it, right? He can also do so through legal practitioners of his choice. He can also do it with a team of legal practitioners. He can appear in court like this and do it by himself, right? Now, the choice is that of Mazi Nnamdi Kanu, to choose whether to pursue this appeal by himself or to bring in lawyers at this point to assist him. If you ask me, I would tell Mazi Nnamdi Kanu to seek the services of lawyers that he can trust, those that he believes can do the appeal for him. Why am I saying so? I'm a practicing lawyer. I've done matters at the trial court, I've done matters at the appellate courts, and I can say it clearly that appeal is a technical matter. Appeal is a technical endeavor. It's like, in secondary school, we did maths, and we also did further maths. Appeal is like further maths. You need to understand maths before you can do further maths, okay? So, my advice, Nnamdi should consider it necessary to bring in lawyers at this point to do the appeal for him at the trial court, even though the law allows you to do it by yourself. But sometimes I see it as a trap of the law. The law puts a trap for you. So, go and do it. Yeah, you want to do it by yourself, so you go and do it. But you will not be able to understand the nuances of law, let alone the nuances of appeal. I would suggest, like I said, that he should get services of lawyers to defend him, but it's still left for him. He can decide to do it by himself. Some people have done the appeal by themselves, and then if your appeal was good, you win. There's no doubt about that. Okay? Now, I'm wishing Nnamdi the best as the events of the appeal unfold. I wish him all the best in this. Nigerians would want to know how this goes. We expect that the appeal will be filed as quickly as possible, and then it will be heard as quickly as possible too. Many thanks always for watching.